Institute. For your seminal role in the Foreign Corrupt Practices Act, and also with the College of Business and Economics and the School of Public Service. And thanks to all of our students. So we're shortly going to have Steve Feldstein, who is our church chair at the School of Public Service, introduce the panel. So we will go from 4:30 until around 5:45 with a discussion and a panel. And then for invited guests, we will have a reception up in the Williams Boardroom in 4201. So what I would like to do in the meantime, though, is to begin this event. I'd like to start with a quote. This is from the manual on the Foreign Corrupt Practices Act. The idea is when a business is won or lost based on how much a company is willing to pay, as opposed to the quality of its products and services, then the entire democratic capitalistic system that we are working to build is absolutely undermined. And that, I think, gets at the heart of the Foreign Corrupt Practices Act. And that's what we would like to have a discussion about and a celebration and a Q&A about today. So with no more further ado, I'd like to introduce Professor Feldstein.
Great. Thank you. Thank you for hosting and welcome everyone. I'm very pleased to be moderating this session and to be joined by such a distinguished panel, both here in Boise as well as in Washington, D.C. Hopefully, Judge Sporkin, you can hear us okay. Well, I'll continue and then we'll see. Right, well, maybe we can turn the volume up. At any rate, I think this discussion comes at an important moment. Not only are we at the 40th anniversary of the passage of the Foreign Corrupt Practices Act, but we are directly grappling with many of the same underlying issues that motivated its signing in the first place. Whether it's the flood of money in politics, the influence of corporate interests in public policy decision-making, or the growth of shell companies, hidden financial transactions, and opaque financial instruments that abet corruption. This is an issue of deep importance. It was certainly an issue of deep importance to Senator Frank Church. I want to read a brief statement that he made in the Subcommittee on International Trade on the issue of corruption. He said, "There is little doubt that widespread corruption serves to undermine those moderate democratic and pro-free enterprise governments which the United States has traditionally sought to foster and support. Several oil companies testified before the subcommittee that they had made huge political contributions in Italy and Korea, for example. They claimed to be supporting the democratic forces who are friendly to foreign capital in those countries, but in fact, they were subverting the basic democratic processes of those two countries by making illegal contributions and were, at the same time, providing the radical left with its strongest election issue. So that while bribes and kickbacks may bolster sales in the short run, the open participation of American firms in such practices can, in the long run, only serve to discredit them and the United States." There's a lot of good issues on the table for our panelists to discuss, and I certainly expect a robust discussion today. Let me quickly introduce our panelists, and then we will go from there. First, we have Judge Stanley Sporkin, who is joining us from Washington. Judge Sporkin spent 20 years with the SEC, serving as the last 7 as the Director of the Division of Enforcement. He then served 5 years as the General Counsel of the CIA. In 1985, President Ronald Reagan appointed him to the federal bench, where he served as a U.S. District Court judge for the District of Columbia for 14 years. Upon retirement from the bench, Judge Sporkin spent 6 years as a partner with the international law firm Weil Gotshal. He was also a founding member of the law firm of Free, Sporkin & Sullivan. Since 2006, Sporkin has been the Ombudsman for BP America. He is also a certified public accountant. So next, we have Jack Blum over to my far right. Mr. Blum began his career as an investigator for the U.S. Senate. He is best known for his investigations of mortgage fraud, the foreign bribes of U.S. multinational corporations and drug trafficking, and money laundered in Central and South America. His investigation of Lockheed Aircraft's bribe payment, which I'm sure we'll hear more about, led to the prosecution of the Prime Minister of Japan and the later passage of the FCPA. The investigation of the drug problem led to the exposure of the activities of General Noriega from Panama and his subsequent indictment. It also led to the exposure of the criminal activities of the Bank of Credit and Commerce International, leading to the closure of the bank and the indictment of many involved with it. Mr. Blum is currently of counsel to Amsterdam and Partners and practicing part-time, working as an expert witness. He has been involved in a wide range of civic and charitable activities. He served for 5 years as the president of the National Consumers League and is currently its counsel. He was a trustee of Bard College and for 2 years as the treasurer of the International Center, a DC foreign policy organization. Finally, to my immediate right, we have Jason Prince. Jason is a partner at the Holland & Hart law firm. He represents and counsels exporters and multinational companies, including one of the world's 10 largest international defense trade companies, on an array of complex international trade compliance matters. He specializes in coordinated internal investigations, voluntary disclosures, and compliance program reviews involving the FCPA, the International Traffic in Arms Regulations, the Export Administration Regulations, and the Office of Foreign Assets Control Trade Sanctions Regulations. Prior to joining Holland & Hart, Jason served as Deputy Press Secretary to Nobuteru Ishihara, a Japanese House of Representatives member, and Japan's immediate past economy minister, as well as a law clerk to Judge Susan H. Black of the U.S. Court of Appeals for the 11th Circuit. With that, please welcome our distinguished panelists. Now, the way we're going to run things is I think Jason will provide a brief overview of the Foreign Corrupt Practices Act, sort of a primer for what it means, its implications, and so forth. From there, we will turn to Judge Sporkin, who I understand has some prepared remarks for the group. We will then go into our panel discussion right after that. So why don't we turn over first to Jason for his overview, and then we'll go to Judge Sporkin subsequently. Thank you.
Thank you very much. As Steve mentioned, I'm going to provide just a brief overview of the Foreign Corrupt Practices Act. We thought it'd be helpful before we dive into the history behind the Act to tell you what the Act consists of. And it has two primary components. First, there are the anti-bribery provisions, and then there are the record-keeping and internal controls provisions. The anti-bribery provisions can be broken down into 5 essential elements. The anti-bribery provisions prohibit or criminalize the payment, offer, or promise of anything of value to a foreign official with the corrupt intent of obtaining or retaining business. Now, you could boil all that down and say it prohibits bribery of foreign officials, but I'm going to unpack it just a little bit, kind of element by element, to give you an idea of how slippery and challenging the Foreign Corrupt Practices Act can be. So you start with payment, offer, or promise. The key thing to note there is that you don't have to actually pay a bribe or provide something of value to a foreign official. Just offering or promising to do so at some point in the future can trigger or get you in trouble under the FCPA, even if you don't actually end up following through on it, if these other elements are later satisfied. The anything of value component means that it isn't just what some of us think of when we think of bribery. It's not just a briefcase or an envelope full of $100 bills. It can be anything that might be of value to that foreign official. So think of tickets to sporting events, or diamond rings, or even one example that isn't necessarily intuitive is if a foreign official has a pet charity, some sort of charitable organization that they're passionate about, and you make a significant donation to that charity, and you do so with the intent of influencing the foreign official, that donation to the charitable organization, even though that money never ends up in the foreign official's pockets, is still of value to that, or could be deemed to be of value to that foreign official, and therefore could be a bribe. The foreign official element is very expansive in that it's not just the government officials, military officers, the sorts of folks we see on television, on the nightly news representing their nation. It's also people who are at lower levels, say at a port of entry, a customs official who has the ability to inspect and reject or permit the import of certain goods that you might be trying to import into that country. But it also includes instrumentalities of foreign governments, and the basic concept there is that those are state-owned or state-controlled enterprises. And if you're dealing in a country such as China, where the Chinese government owns or controls a vast portion of the economy, that means many of the companies you might be dealing with, even though they look like any other company that you're doing business with, that's a private company, those are actually publicly controlled or owned by the Chinese government, and therefore their employees qualify as foreign officials. To just give you a brief example, And let's say your company sells pharmaceuticals or medical devices, and you want to grow your sales in China. And let's say you go into a Chinese hospital and you go to the doctors in that hospital and say, we really want you to buy our product. And so go to your procurement officers and tell them this company has the very best of this particular product, and I, as the doctor, want my patients to have this product. The issue there is that if you then pay the doctors to do that, and whether you call it a commission or anything else you might want to call it, if you're paying the doctors to do that to give your company the business advantage of then selling into that hospital, in China, the vast majority of the hospitals are owned by the Chinese government, and so those doctors, chances are actually foreign officials, and so you could therefore have been running afoul of the Foreign Corrupt Practices Act. And the last point I'll touch on anti-bribery provisions is the concept of obtaining or retaining business. The federal court has made clear that it's not just the securing a contract or getting a contract renewed. It could be something such as getting a customs officer, for example, to turn a blind eye to the customs duties that are owed and not make you pay them, or to pay some tax officer in that country a bribe in order to get them to not make your company pay the taxes it's supposed to pay. So it's anything, arguably anything that could give your company a business advantage over the competition. The books and records and internal controls provisions are something that Judge Sporkin can speak about, because he was a driving force behind their creation, because those provisions apply only to issuers. And issuers are basically companies that publicly trade their securities on a U.S. market, or that are required to file reports with the Securities and Exchange Commission. And you find these provisions in the Securities Exchange Act. The record-keeping provisions just require that companies record their, or keep books and records that in reasonable detail accurately and fairly reflect the transactions and dispositions of their assets. And you can boil it down to say, if your company pays a bribe, you have to record it in your books and records as a bribe. If you call it a miscellaneous outgoing or a finder's fee or any number of other creative terms you could use to try and describe the bribe, that would run afoul of the record-keeping provisions. The internal controls provisions require for managerial oversight of your assets, the generally accepted accounting principles compliance. You need to have periodic comparisons of your recorded and actual assets. And again, those provisions apply specifically to issuers. The anti-bribery provisions apply to issuers and non-issuers. I won't go into detail about the breakdown of the different types of companies and individuals who fall within the FCPA's ambit, but the point is, whether you're a privately held company or a publicly traded company, you can be subject to the anti-bribery provisions. Now, there are two chief enforcement agencies in the FCPA arena. You have the Department of Justice, that oversees criminal enforcement actions or criminal prosecutions. And then you have the Securities and Exchange Commission that handles civil actions against those issuers that I mentioned a moment ago. And often you'll see the Department of Justice and Securities and Exchange Commission team together and bring tandem enforcement actions against an issuer if there's reason to believe that there's been criminal conduct or willful misconduct. Last thing I'll note is that you're going to hear from Jack Blum and perhaps myself as we talk about the dangers of using third-party intermediaries. And many FCPA enforcement acts, and Jack will talk about the investigation that led to the FCPA, involve these third-party intermediaries who they could be anything from a broker to a sales representative to a distributor, a joint venture partner. These third parties who serve as a go-between between your company and a foreign customer or foreign official. And just because you're using that intermediary doesn't mean you can shield yourself from liability under the FCPA. If your third-party intermediary pays bribes on your company's behalf, then you can be potentially criminally liable for the bad acts of that third party. And you don't have to have actual knowledge of the activity of that third party. If you disregard a high probability that that third party actor is paying bribes to a foreign official. In other words, stick your head in the sand and try and pretend like you basically don't know about it and you don't want to know about it. That could be essentially knowledge under the FCPA that could result in your company or you as an individual employee or officer of that company having an FCPA enforcement action brought against you. So with that, I'm going to turn it over to hopefully Judge Sporkin to talk a little bit more about the events leading up to the FCPA's enactment.
Good evening. I want to thank the Church Foundation for this invitation, and to be able to discuss something that is very important to our country and to me personally. We never intended, somebody just didn't sit around at long table and discussed, let's have a law that will ban bribery. It didn't happen that way. The way it happened was that I was watching, remember the old Watergate hearings at night, and after they had been, we'd been through them, they brought as witnesses a number of people from these major international corporations, and they testified as to what they were doing. And what they did is they discussed bribing these corporate officials. It was never disclosed before. And the questions came up, how do they do it? And how do they intend to get away with it? What intrigued me was that they went about this in a funny way. What I was interested in is how does a major corporation with big 8 or big 4, used to be big 8, that big 4 accounting firms, let this stuff happen without noting it. And so at the time I was the director of enforcement at the SEC, and I started an inquiry into this, and I had sent my people out, my investigators out, to find out how they did it. And they came back with the most interesting stories that you can believe. They would say that these companies were establishing what they called slush funds, and they would take the money to the CEO. CEO would have an office safe. He would open it up and he would put cash in it. And then when anybody in the company needed money for bribery or other kinds of purposes, they would come up there, open the safe, take the money, and deliver it to the foreign official. And the foreign official then came through and gave the company what they wanted, the contract or anything that they wanted. And we started to find this out. And it was repetitive. It wasn't one company. It was major. It was on big scale. And we said, well, how did you do this? And they would find all different kinds of ways of setting up the slush fund. And then I said, well, why didn't you, the accountants, pick it up? And they said to me, well, it was not material. And in the accounting profession, anybody there understand accounting and disclosure, that it has to be in a material amount. And so that's the first thing I had to overcome and say, well, what is an immaterial bribe? And we got by that hurdle in two ways. The first way was to say that the bribe was unlawful. No bribe is lawful that I know of. The bribe was unlawful, and that therefore, as an unlawful act, the company can face serious consequences. And so that would be a reason to disclose it. That since it was material in that way, that the company could be prosecuted. The other aspect of materiality was tracing the bribe to find out how much and what business it gave the company. So if a bribe, through the bribe, the company obtained hundreds of millions of dollars worth of business, then that's material in theory that if it's caught and you can't bribe anymore, then you don't get that business. So we were able to overcome the materiality issue in those two ways. The unlawfulness of the bribe, and secondly, what did it produce? So as you can see, I wasn't going to be deterred. And what happened after we did about 65 companies, we would go in, find that they were bribing, and go in and tell them we're going to sue them. Now, what happened here is that while they gave up all these reasons as to why it's not material and why it's not a securities SEC issue, that after we overcame that, then we started to sue these companies. And the mere fact that we told the company that we're going to sue them, and we're going to say that you're paying bribes and you're not fulfilling your responsibilities, they all caved. So of the 65 companies that we were going to sue, all of them took what's called a consent decree, which is a decree that said that the court will issue an order that says that that you shall not do this again. And if they do it the next time, they'll be then tried for breaching the order of the court. And so that's the way we cleaned it up. And what happened was, there are several great senators. One is Senator Proxmire and the other Senator Church. And they both did not like what we were finding, the numbers of cases. And they came to me, they said to me, tell me, how do we fix this problem? We need a law. Everybody always needs a law. And I said, well, Senator, we're doing all right without a law. And he said, well, I want to give you a law anyway. And he said, well, fine, give us a law. And he said, what kind of law do you want? And I said, well, since I'm not asking for the law, I'll come up with something. What I came up with was the fact that I learned that of all the laws in the books, there's not one that says that a public company who takes money from shareholders, that they have to keep accurate books and records. They have to say that if they're going to pay a bribe and they paid a bribe, they got to reflect it on the books and records as a bribe. And my theory was that no company wanted to show in their books bribes. And so that was, as far as I was concerned, that was good enough. And the senator said, fine, we'll pass the law. And that law says that you got to keep accurate books and records. And I said, fine. Then my chief accountant and the commissioner, the chief accountant of the SEC, said they ought to have proper internal controls, which would show that the bribe has been paid, or that there were mechanisms that they would not be able to catch the bribe. So that became what's known as the books and records provisions of the FCPA. The next thing that Proxmire said, no, that's not going to be good enough. I want a law that says you shall not bribe, and that will be a crime. And so that became the second part of the law. So you had books and records, and the second part was the substantive violation, was the bribery provision. Now, we started to run into problems. What were the problems? Well, as director of enforcement, my responsibilities were to make sure that the markets were honest and fair. And I did not have the wherewithal, the budget, to do these other things that I was doing, looking for the bribery and whatnot. And so, and there was nothing in the budget to provide those funds. So we had to come up with we had to come up with something that was going to help us find out where this skullduggery was taking place. And what we came up with is when we went, and I would make a couple of speeches, I would ask the question, where were the accountants, where were the lawyers, and sort of shame them into going in and finding where all this bribery was. And so what we did is, even though I didn't have the money to send the people out to find all this bribery, we in effect enlisted the help of the accountants and the lawyers to find it for us. And they were all too happy to do it. Why? Because they made a lot of money. And lawyers like a lot of money, and accountants too. And so they're very happy to go out and find the bribery for us. And what happened is that when they came in with it, we either gave them a pass, or else was bad enough we would sue them with their own, using their own work as the basis of our lawsuit. And so that really became the way that we dealt with this problem. And of course, Senator Church and Proxmire, they were able to get this law enacted fastest I've ever seen any law go through. Nobody opposed it, and it went on the books, and it's been on the books for many years. Well, it's 40 years now, and it's working. I'm sure that as we go on, they're going to find other ways of getting around the law. And for example, they might overbid a contract and pay, instead of 20 million, 30 million, and the difference they'll use in some way to get to the people. So you've got to be vigilant and make sure that they're not getting these new ways of getting around the law. And I think I think that the government, the SEC is not enforcing it as strong as it should. And so it's all up to the Department of Justice. And so when they bring a case, it's a criminal case. It's not just a consent decree with an injunctive action. And so that's really the way they're doing it now, and it's been very successful. It's cleaned up a lot of messes, and it's interesting that you can get involved in something that I never expected this. I never expected this was so big, and this was what we would find.
Great. Well, thank you. Well, thank you for why don't we pause here for a moment? Thank you, Judge Sporkin. This is a really good opening frame and very, very personal as well in terms of the specific experiences that led up to the passage of the FCPA. And I think this is actually a good moment maybe to turn and ask a few questions of my panelists, starting with Jack Blum, around some of the other key events that happened around the passage of the FCPA that led to it being developed and signed into law. In particular, I'd be interested, Jack, in hearing from you a bit about the church subcommittee's Lockheed Tanaka investigation. what that exactly was for those who haven't had a chance to read into it, and then to understand the political ramifications of how that led to FCPA. So, Jack, why don't I turn it over?
Okay, well, first I want to thank Gary Wensky for his hospitality and help in coming here, and the great hospitality I've had from the college. I really do appreciate it. Second, I'd like to say hello to Judge Sporkin, who I haven't talked to, I think, in 40 years. The story, from my perspective, begins with a request from the Senate Foreign Relations Committee to the SEC for all of the documents they had accumulated in the course of their bribery investigation.
I didn't get the, can I have that question again? It's, the communication here is not so good.
Well, what I was saying is that our investigation at the Senate Foreign Relations Committee began when we asked you for the books, your records from your bribery investigation. And we received boxes and boxes of material that showed that major corporations were paying bribes. Now, the question is, if the SEC is doing the job, why should the Senate care? The answer was that as good as the SEC's work was, it didn't create the public impetus that would lead to the passing of a law. And we started to delve into what was in those boxes. And at the same time, there was a very curious event. A guy showed up in my office. His name was Ernie Hauser, a sleazeball of major dimension. His business was selling crash parts. That is to say, parts from airplanes that had crashed. And some of you may know that that's completely illegal, that all parts have to be registered. Ernie Hauser, it turned out...
I just couldn't hear the question. Could you?
Oh, I don't think there was a question that was directed.
In one sentence, what was the question?
No, there's no question. I was telling the story of how the Lockheed investigation really came about in the Senate. And it started with, as I said, this character, Ernie Hauser, who was a real sleazeball, who announced that he was the bag man who paid Franz Josef Strauss, who was the German Minister of Defense, on behalf of Lockheed to get Germany to buy the F-104 Starfighter. Now, the F-104 in Germany was called the Widowmaker because half of those fighter planes crashed. And the question was, why did Germany buy the planes? And here's Hauser saying it was because of a bribe. So I began to go around Germany to find out whether that in fact had happened. Well, it turned out that Hauser was a liar. He purported to have a diary that explained the days when he paid the bribes. The Germans had records that showed the diary was bogus. It had him signing into various offices on a certain day. The record showed he didn't sign in, and then there were other days when he said he didn't sign in, and the record showed he did, so the diary was bogus. He had sold this diary to a man named Gerd Heidemann, who was a journalist for Stern magazine. Gerd Heidemann later went to jail for forging Adolf Hitler's diaries and selling those forged diaries to the London Times. All of this is pretty irrelevant to the Lockheed story, except as I traveled through Germany, numbers of people who knew about Lockheed's agents in Germany said, look, things happened here, but the real problem was in Japan. Now, mind you, in Germany, Lockheed had hired a man named Gunther Frankfahler as their agent. This man was a Class A war criminal who was indicted before Nuremberg, He was on the board of directors of IG Farben and was involved in the manufacture of Cyclone B gas, the stuff that was used by the Nazis in the extermination camps. That was Lockheed's agent, and that was the guy I was trying to talk to. Never found him, but we found out that there was a big problem in Japan. We went back to the documents, and there were a pile of documents in Japanese, which hadn't been translated because it's very costly and time-consuming to translate all of this stuff into English. We quickly found out that the Lockheed agent in Japan was a man named Yoshia Kodama. Kodama was the guy who was hired by the Japanese army when they invaded China to fence all of the loot the army collected. He actually put it up for sale. He was involved in other criminal activity, but he was indicted as a Class A war criminal, and he had been hired by Lockheed as their Japanese agent. We found out that in Japan after the war, when his indictment had later been dismissed, he went into the business of pornographic movies, bribing people in labor unions not to cause problems, connecting to the Japanese Yakuza. In other words, a thoroughly despicable human being. All of this led to our having to make public all of the things that had happened, the role of Kodama, and the many countries the documents showed Lockheed had made payoffs in. And these included countries in the Middle East. It included Italy. Out of those documents, Prince Bernhard and Queen Juliana in the Netherlands, Queen Juliana abdicated. It was a laundry list of countries and bad guys. Now, there was one thing in those hearings which really is in my memory, and that was Frank Church questioning the Lockheed official. And the questioning went something like this. Well, explain to me why you paid the bribe in Bolivia. The Lockheed official said, well, we were selling C-130 cargo planes, short takeoff and landing, and those planes were very important to us because we needed to keep the production line open, so we paid a bribe. Senator Church said, well, was there any competition for that C-130 plane? And the answer was, well, no, Senator, there was no other aircraft that could compete, but there was competition. Church said, well, what was that? And he said, the rest of the budget of Bolivia. Senator Church said, do you mean health care, food, nutrition, education? The Lockheed guy said, yes, Senator, precisely. We paid the bribe so the money would go for the airplanes. It's one of those moments where you just stop and you realize how awful and difficult a problem we were dealing with. The notion that a budget of a country could be turned around by the payment of a bribe was really quite startling. Now, this story is really quite interesting. It goes on, but I won't bore you with all of the details of it, except to say that as we did this work, we came upon a second problem, which is that the Japanese government began to ask for the Senate's documents. At this point, because they had come from the SEC to the Senate, there was a problem of turning them over. Under Senate rules, that could only be done by a vote of the Senate. The government of Japan said, we need those documents and we need them authenticated, and that included the hearing testimony. All of this led to the first negotiated mutual legal assistance agreement between the United States and another country. It was a real groundbreaking event. Finally, what I would say about the issue of bribery, I've been working on this for many years, At the time the hearings were held and the initial work was done, the international business norm was you pay the bribe. And everybody accepted that as normal business behavior. After the hearings, people began to say, well, maybe it shouldn't be normal behavior. And we got some legislation like the Foreign Corrupt Practices Act. But then for a period of almost 15 years, very little was done. Very little enforcement came because people felt, well, this is going to mess with companies' ability to make sales overseas, and foreign competitors will have an advantage. So the Germans called the tax-deductible bribe Schmiergeld, wonderful German word. And the argument from the business community was, hey, we can't stop paying bribes if other people are paying them and it's legal for them to do it. Well, over the intervening years, we now have a network of treaties and agreements that have made bribing foreign officials to get business criminal around the world. There's an inter-American agreement, there's a European agreement, and then finally an international convention. And that has changed the norm. There is now no expectation that that is normal business. We've come to a point where everyone in the world understands that this is something you don't do. Now, finally, there's a question here, and the question is, what is the real underlying problem of bribe payment? Let's take a look at two specific countries, Equatorial Guinea and Angola. Both of them have oil, and in both of them, the senior officials of the government have managed to skim most of the wealth that comes out of that oil. In both countries, per capita income is way up in the top 10 of world per capita income. In both countries, on standards of care, standards of living for average people, the countries are down around 160, which tells you how much wealth is being skimmed and what the rest of the population looks like. Infant mortality in Angola is shocking. This happens because of bribery. And I think that it should be clear that this is detrimental. It's something that every one of us should understand should never be happening. And I think the intervening years of treaties and arrangements have now made it so that it will be increasingly difficult for it to happen. And with that, I'll quit and turn the floor back over to you.
Well, thank you, Jack. I think that was really a wonderful synopsis of the different issues surrounding FCPA, and also a nice way to give us some thoughts about where what the rationale is and potentially where FCPA can go. Certainly, I love the Angola example. I'm probably one of the few people in this room who's been to Angola several times, arguing against corruption in that country. It's not just government; it's also family, especially Isabel dos Santos, the daughter of the head of state there, who was just recently left office, who's among the wealthiest women in the entire world for a country that is absolutely in poverty. So it really shows you what effect corruption can have. I want to turn to Jason to ask him a follow-up question based on what Jack described in terms of the Tanaka case, because I think the issue and idea of a norm being such a powerful thing is so fascinating to me about how you can pass a law and over time change behavior. And I think what's important is that with the Tanaka case and the bribery that was uncovered with Lockheed Martin, we saw the fall of a prime minister, which is, I think, one of the most senior level officials even today who has been directly implicated through corruption. Jason later on served, as you heard, as an aide in the Japanese parliament. And I'd love to hear your thoughts about what you saw 25 years later in terms of the lingering effect of that and other related thoughts on corruption. So let me turn it over.
I think I can try and help put in context just how significant the investigation that Jack just described is, not just in this country, but in another country, in the sense that the Lockheed scandal that brought down Prime Minister Tanaka is considered by many to be one of the single most important events in Japanese political history following World War II. I mean, it was massive. It's been called a shock to the system of the country of Japan. And roughly a quarter century later, when I was in Japan working in the Japanese Diet, the Japanese Parliament, that shockwave was still being felt in Japanese politics and in Japanese culture. I was over there thanks to the Henry Luce Foundation, a New York foundation that each year sends 18 American professionals to different parts of Asia for a year of work experience and cultural immersion. And I was fortunate enough to work for Nobuteru Ishihara, who was a member of the Japanese House of Representatives. And a few weeks before I arrived, the new Prime Minister Junichiro Koizumi, had appointed Ishihara as the Minister of State for Administrative and Regulatory Reform. And when I arrived, there was a lot of buzz in the Japanese media about the new Koizumi administration. And one aspect of that was the new foreign minister in the Koizumi administration was Makiko Tanaka, the daughter of Prime Minister Tanaka, who, as Jack had noted, due to the bribery scandal, had been criminally prosecuted. And at that time, the Japanese newspapers were recycling over and over and over these stories about the Tanaka downfall and what a significant event that had been. And so it's, again, 25 years later, it was still in the news. And so, and I don't know if it's been pointed out yet, but if you look at this photo here, sitting directly to Senator Church's left was none other than Jack Blum at those hearings. So you think about it, we have here in this room someone who played a central role in the Church subcommittee investigation that helped directly lead to not just the FCPA, but one of the single most important political events in Japanese history. So it really can't be understated what a big deal the Church subcommittee and its work were, as well as, you know, it wouldn't have come to light if not for Judge Sporkin and the SEC's great investigative work. But one other thing I wanted to note about my time in Japan and the relevance of it to the FCPA and anti-corruption is that part of my job was to go from constituent event to constituent event, helping to represent Minister Ishihara. And there would be, throughout the month of January, which is a festival season, we would be going to up to 15 different constituent events a day, literally running from event to event to event. And even if we arrived early, we would apologize profusely for being late, and we would then engage in the ritual exchange of gifts. And these are small gifts. We're not talking about, briefcases of cash or bars of gold or the types of things that got Prime Minister Tanaka in trouble. These are just cultural niceties, the things that you exchange to be socially appropriate. It's Japanese etiquette. So it'd be, bags of Japanese green tea, for example, or small Japanese snack food, things of that nature. But it's a way of showing your gratitude to the person who's hosting the event, and then they would provide a gift to us to show their gratitude for us attending. And if you've spent any time in most any Asian country, but in particular Japan, China, South Korea, gift giving is a crucial part of the culture. It's a way that people in the business community form business relationships and build up that trust, so that over time, once you've developed that trust in the business context, then you can have a long and prosperous relationship together. Now, the challenge with that for my clients, the companies I help to represent, is that gift giving is a necessity in order to engage in business in these countries. But you can see how it's difficult to draw a line between what is just socially appropriate, what is etiquette, and what is a bribe. And again, the FCPA, anything of value could get you in trouble, and there's no de minimis exception. So the companies struggle with how do we provide instructions and bright lines and rules to our employees and to our third parties, our sales reps and distributors and others who are representing us in these countries, and give them a sense of this is okay to provide, that you can give this to a foreign official, but this is completely off limits. And drawing those types of bright lines, it's challenging, and providing the training to help people understand where those lines are has become something that all multinational and exporting companies who are dedicated to compliance struggle with. And it's, again, it all arose out of what Judge Sporkin discovered, and then what Jack Blum and the church subcommittee helped to drill down on and further bring to light, and that now is fully in the consciousness of companies not just in the U.S. but around the world, because the Foreign Corrupt Practices Act has very broad jurisdictional reach, and so it's not just the U.S. companies that can be subjected to it, but, for example, of the 10 largest FCPA enforcement actions of all time, the 7 of those enforcement actions were against foreign companies. Only 3 of the top 10 were U.S. companies. So foreign companies that are multinationals, and in most instances are ensnared by the FCPA because they publicly trade their stock on for example, the New York Stock Exchange, they're then subject to the act. And so when Jack was talking about how the FCPA has had a global reach and has basically changed the norm, as Professor Feldstein said, it truly has changed the norm around the globe, and done so in a way that on a day-to-day basis affects companies here in Boise, Idaho, and around the world.
Great. Thank you, Jason. I want to direct a question back to Judge Sporkin, but before I do that, I also want to encourage you to start thinking about your own questions and writing them down. We have a group of different people who will collect the note cards that I think you should have near you or in front of you, and then they will bring those up to me, and I will continue channeling your questions. So I'm going to ask 1 or 2 more, but then I will also look for contributions from the audience as well. And I also want to mention that for those who are online, who are watching, if you use the hashtag FCPA40, you can also ask questions online that our team here will collect and pass over to me. Judge Sporkin, if you can hear me,
Yeah.
I wanted to ask you a question that builds on the last point Jason made, which is that he talked about the concern that the FCPA would lead to a competitive disadvantage for U.S. companies in particular. At least at the time of the passing of the FCPA, this wasn't an established norm, and this was really the first country, I think, that had such a strong anti-bribery law on the books. So in your opinion, do you think that the passage of the FCPA did provide a competitive disadvantage to U.S. companies, and how has this evolved over time, in your opinion? Thank you.
What's the question?
Did the FCPA cause a competitive disadvantage?
Let me see if I have the question right. Is the question, what does it do with the competitive balance?
Well, the question is, when you look at U.S. companies that were the only ones who faced such a strong law, did the FCPA provide a competitive disadvantage for U.S. companies and an unlevel playing field for at least the first 10 years or so after the law had been in effect? How did you see this play out?
Well, I know that was some of the criticism of the law, but you got to understand that these are American companies vying with American companies as well as foreign companies. So you're taking that aspect out of it, and I think all companies are able to do better when there isn't any of the schmiergeld or any of the bribery involved, so that everybody can compete on an even playing field. The American companies as well as the foreign companies. And the other thing is, nobody wants to be charged with the crime of bribing somebody. And they just didn't want to get involved in that. And so I think that if you ask me at the beginning, would there be a competitive issue? There may well have been, but I think that got completely erased when everybody started to say, no, we're not going to bribe anymore. No. it's going to end. Now, they're still doing it, but they're doing it, I guess, with a little bit more finesse than they were in the past. But I don't think the accountants know about it anymore, and I don't think the lawyers know about it, because I don't think that they would in effect risk losing their licenses for getting involved in a bribery scheme.
Great, thank you. Let me turn to others on the panel for their thoughts.
Well, for the first 10 years or so of the Act's presence on the books, there was not a lot of enforcement activity. And the point that I'm aware of where the Justice Department became incredibly active was during the first term of President George W. Bush, who recognized that there was a serious corruption problem that we were dealing with in Iraq, where everybody was on the take one way or another, including American contractors who were supplying U.S. troops. Money was being stolen on all sides, and bribes were being paid on all sides. And he directed the Department of Justice to go to work hard on this issue. And we then got a spate of cases which really sent a message to the American business community, and these were terrific in terms of their impact. Most of those cases were settled with the payment of large sums of money. One of the cases involved a company called Halliburton. You may remember Halliburton was a major military contractor in Iraq, but Halliburton was caught having paid significant bribes in Nigeria to get a contract to build a gas platform. And that case led to the president of the subsidiary that paid the bribe going to jail. Actually, he served a criminal sentence. And it led to many companies saying, we have to self-report, because the Department of Justice said, those of you who do an internal investigation and come in and admit what you've done, we're going to treat with very differently than people who say we didn't do anything and then they get caught doing it. So the amounts of money that the U.S. government began to collect from these companies that had paid bribes got to be very large. I can't put a number on it, but we're talking about many, many billions.
Great. Jason?
Even within the last 10 years, there's been a significant shift in the amount of foreign anti-corruption activity and enforcement. 10 years ago, a lot of the companies I worked with were finally aware of and concerned about the FCPA because, as Jack talked about earlier, the Department of Justice started ramping up its enforcement activity. But it's really been within the last few years that companies have started to say, we need not just an FCPA compliance policy, we need a global anti-corruption policy, because it's no longer the case that the FCPA and the DOJ and SEC are the only sheriff in town, because gradually over time, our foreign trade partners, our allies, have started to get increasingly involved in enacting sweeping anti-corruption legislation and, more importantly, actually enforcing it. And as a result of that, we're seeing more and more collaboration between U.S. law enforcement and prosecutors and their foreign counterparts. So, for example, there may be an enforcement action that's brought against a German company by the U.S. government, and when it comes time to announce the settlement that that company's reached with the Department of Justice, they'll actually coordinate and, down to the minute, time the announcement by the U.S. government and the German announcement so they each make public press announcements about this enforcement action at the same time. That's how closely they're working together. It's not just a matter now of sharing documents and information. They will, and to a certain extent, in certain contexts, I've seen instances where in a plea agreement where an individual who's been prosecuted for violation of U.S. law, in that individual's plea agreement, they'll agree with the U.S. government that one of the conditions of this plea arrangement is that they have to cooperate with the German public prosecutor's office. So we're seeing now this close hand-in-hand relationship between U.S. and their foreign counterparts, and that has helped to level the playing field to the extent it wasn't level in a way that it should be.
Great. Great, thank you. I want to ask a follow-up question based on kind of where FCPA and other types of corruption is going, and then I will take a second while they're answering to look through some of the questions that you've given me. So, but my question is sort of, as we look now at FCPA at 40, and this is for really the whole panel, on the one hand, with a norm that it does exist where accepting and giving bribes is considered to be something that's frowned upon in almost any country, yet it does seem like the amount of illicit transactions has not really stemmed, and that what we're looking at is less of a change in culture per se, but more of a movement to different types of transactions, whether it's shell companies, whether it's kickback schemes or so forth. I think the Panama Papers that were disclosed a couple of years ago point to the many various devious ways people have found to launder money. So I guess my question is, one, do you think that's true? Are we merely seeing a different form but a type of illicit transaction that's still continuing? And two, if so, what are next further steps that need to be taken along the lines of what Jason proposed at the end?
Well, a couple of thoughts on that. One of the ways that some people have gotten around all of the anti-corruption legislation and the treaties is to hire middlemen, or not really hire them, but have middlemen who work with corrupt officials, particularly in mineral-producing countries. And these middlemen make arrangements to set up shell companies that are partially owned by government officials. And then the shell company is flipped, sold, to a major company wherever in the world, and the people who own shares in it, in the shell company that had the license to do the mining, are suddenly very rich. Now, the evil here is the anonymous corporation. There are many jurisdictions around the world that allow you to set up a corporation which have nominee officers and directors where there is no requirement, absolutely no requirement to keep books and records, where the directors and shareholders have absolutely no fiduciary responsibility, and where the records are not in the country of incorporation. The British Virgin Islands, for example, has upwards of 500,000 corporations, most of which are anonymous. And it's through things such as those anonymous corporations that this continues. There is a significant push underway and pending legislation that would bar business from these anonymous corporations. But that seems to me to be the key point in terms of shutting down what we're talking about. But let me say that the major corporations have really gone a long way to cleaning up their act.
I would agree with that, and Jack just noted that at the time of the investigation into the Tanaka scandal, he talked about the middlemen in Germany and Japan, and I had mentioned how that remains an issue today. And so for the most part, I don't think it's necessarily that companies, at least not the companies I work with, have issues with deliberate, intentional efforts at the highest levels to engage in wide-scale corruption, not of the sort that Judge Sporkin and Mr. Blum discovered as part of their investigations. The challenges they face are, how do you, if you're a multinational corporation that has employees or third-party agents scattered all over the globe in different countries, and with each country having its own culture and concepts about what's appropriate and not appropriate, and its own laws related to anti-corruption, how do you develop a global compliance program that can protect your company against bad actors who might be going out and paying bribes? And no matter how good your compliance program is, and no matter how much training you provide, you can't completely insulate your company from those bad actors. And there's the UK Bribery Act, for example, has an affirmative defense of if you have a solid compliance program, an effective compliance program, you can use that as a way of defending your company against prosecution of your company. It could be that the individuals who pay the bribes end up going to jail, but your company is shielded from criminal prosecution because you can show we had a compliance program that hit all the hallmarks of an effective program, and we just had a bad apple. And that's something that the FCPA does not have, and is something that, as defense counsel, I think would be helpful. It'd be helpful to have that bright line written affirmative defense in the statute that lets companies know, if you have this sort of program, then we're going to, we're not going to prosecute you as a company. And why not incentivize companies to have effective compliance programs? I know there are counter arguments against it, but in my mind, that's something that would be the next step in making the FCPA even more effective.
Let me turn it over to Jack. I think he has a point as well on this.
I'd just like to add to the excellent comments that the case of China was brought up, and China has, despite a lot of predictions, a lot of Chinese business and Chinese power has increasingly moved towards state-owned enterprises, and I think that was an excellent point that was brought up before. There's a lot of confusion. I think it's also interesting, though, that under Xi Jinping's current China, which is now the world's second largest economy, right on track to become an even greater economic power, there has also been a lot of internal movement towards a strike hard campaign towards taking out bribery. So we can also see this as sort of a movement and a moment in, I think, which you can get more global compliance around these issues, because clearly the idea is to have more transparent practices. So that's just sort of what I wanted to add and I think that applies to the BRICS in general, to the Brazil, Russia, India, China, to all the emerging markets who are struggling with these issues. And then on a totally unrelated note, those students who need to leave at 5:45, please feel free to leave, and we're going to continue going until 6.
Great, thank you. I have and the crowd rustles. I have a question from the audience, which is actually a pretty good question, so some of you may want to stick around for a minute. And Judge Sporkin, you're more than welcome to opine on this as well as I ask the question. So recently in the news, we learned that the Justice Department has threatened former Trump campaign manager Paul Manafort with an indictment under the FCPA. So the question is, how did Manafort potentially violate the FCPA, at least under the allegations that are emerging from the DOJ accusations, and what type of penalties for individuals knowledgeable of the Corrupt Practices Act but not directly involved with those entail?
I'm somewhat perplexed because, as I understand the situation of Mr. Manafort, his problems really revolve around money laundering, foreign agents registration, and similar matters, not really FCPA. Now, perhaps he was involved in some business transactions which were potentially corrupt, but more likely it was a question of laundering money that he didn't pay tax on when he was getting it from overseas sources, and then wanted to bring it back into the U.S. And he did that by buying real estate in the U.S. through an offshore anonymous shell corporation, and then getting a bank to put a mortgage on the property, and he would take the proceeds of the mortgage, and that would be tax-free because it's debt. That seems to me to be his risk.
Other thoughts? Or
no, I can't say that I've seen or been able to study the allegations against Mr. Manafort to the extent necessary to opine on whether he may have violated the FCPA. So I think Jack's comments are good and helpful ones, but I'll leave it at that.
Great. Here's a more generalized question from the audience. And I want to make sure, Judge Sporkin, that you get first crack at this if you are interested in answering. So the question is, when corrupt practices happen in this day and age, who is penalized? Is it the individuals themselves who are involved, such as the officers in a particular company, or is it the company as a whole?
Close question. Who gets prosecuted, the individuals or the company?
Was it?
Who gets prosecuted, the individual?
Yeah, that's a good issue. And the question of who gets punished. There's been some papers written that indicate that the individuals ought to get punished. When we were starting out in the program, I decided that we're going to sue the companies. Why? Because the companies can then take action against the individuals and get rid of them. And it would have been too much of an effort to go out and try to find out who are the specific individuals. I think as we more refine the program, then I think, yeah, some individuals ought to be picked up. But the important thing is to go after the companies and have them do their dirty work, have them go out and clean up the mess, have the directors clean up the mess. It's their responsibility, and it should be done. But you don't have the manpower, let's face it, to go out and get every and get every individual who may be involved in the bribe.
I think we're talking here about one of the most complicated problems in corporate governance that there is. There are a number of major corporations that have been engaged in criminal activity. One example is Wells Fargo, but Volkswagen is another one. I could go down a laundry list, unfortunately. In the case of HSBC, they laundered in currency close to $1 billion for the Mexican drug cartels. And the response was to levy a fine on them, which, given the overall corporate earnings, was something that amounted to a parking ticket. And you say, well, what is this going to do, and who's going to pay that fine? And the fine is going to be paid by the shareholders of the corporation. The officers and directors will be covered by insurance, and holding them personally liable in a criminal case is a prosecutor's nightmare, because the paper trail, the number of things you'd have to prove to make the case beyond a reasonable doubt in a courtroom against an individual make that criminal case close to impossible. So now we have to figure out, what exactly do you do when there's a corporation like HSBC, like Wells Fargo, that does things that are obviously criminal, that goes beyond simply giving them a parking ticket. And that's a problem that the society is going to have to deal with, because it's increasing and it's very painful.
One note is that there has been an increasing focus by the Department of Justice on individual prosecutions versus prosecutions of companies. And you may have heard of Sally Yates, who President Trump fired for refusing to enforce the travel ban. But before she came to public attention in that context, among the white-collar defense community, she was well known for, in particular, being the author of what's known as the Yates Memo. And there's debate as to whether the Yates Memo was essentially just reflecting long-standing DOJ policy, or if it was truly a shift. But bottom line is, the Yates Memo emphasizes the importance of prosecuting individual wrongdoers and encouraging or incentivizing companies to report on or to identify, voluntarily disclose to the Department of Justice who those individual wrongdoers are, as determined through the internal investigations that the company performs. And one offshoot of that, that focus on individual prosecutions, is that for many years, when you prosecute a company or bring an enforcement action against a company, the company doesn't want its name being dragged through the mud in the media, and doesn't want to have to pay the money and devote the time and the resources necessary to fight the Department of Justice. And so in many instances, they would just settle. And as a result, the courts never had an opportunity to weigh in on the Department of Justice's position or arguments as to whether or not that company had violated the law. And so we didn't have what they call case law, opportunities for judges to write opinions that then can become precedent and can establish some bright line rules that I as an attorney can use to help guide my client. But when they start focusing, when the Department of Justice focus on individuals, if their settlement is you maybe go to jail for less time than you would otherwise, and individuals don't want to go to jail. And so we see more individuals who are actually fighting the DOJ going all the way through trial, and as a result of that, we're getting written opinions from trial court judges, appellate court judges, and that's helping to develop a body of case law to give us more guidance as to what the courts think the FCPA says and what the FCPA prohibits, as opposed to what the DOJ thinks, so that the DOJ is not acting as judge, jury, and hangman.
Excellent. Thank you, both of you. Well, we're nearing the end of our time right now, and I want to give Judge Sporkin an opportunity for some closing remarks. Before doing so, I have a question that I'd like to direct to Judge Sporkin to think about as he considers what he would like to close with, which is that in the course of several hearings about U.S. corporations' questionable payments to foreign officials, Senator Church said, what we are concerned with is not a question of private or public morality. What concerns us here is a major issue of foreign policy for the United States. So Judge Sporkin, if you have any final thoughts, including why corruption is not so much an issue of public morality as it is a foreign policy concern, please do share.
What's the question?
Ask him to repeat it.
What?
Ask him to repeat it. I didn't get it
Yeah,
either.
I can repeat the question if you like, if you can hear me.
Can you give the question again?
Right. So if you'd like to, I first want to invite you to deliver some closing remarks. My small question as you deliver the remarks is, Frank Church emphasized that fighting corruption was not so much a question of public or private morality, but a major issue of foreign policy. So as you think about how you want to close, I would be curious to hear your reflections on Frank Church's words.
Well, I can't disagree with that, but I don't. You understand we have our own laws, and the last thing I would want to get involved in enforcing the laws is getting involved in foreign policy. I think the point that we did is we kept it simple. We know that a corporation is responsible for the acts of its officers and workers, and so we kept it simple. We charged the corporation with those violations. Now, to bring in foreign policy, I think that's what got all the lawyers and accountants all screwed up, because they wanted to know whether it's good or bad for America, and that's not the issue. The issue is whether these people violated the domestic law, and they did, and that therefore they should be punished for it.
Thank you, Jack. And
I would say that it is a serious issue for American foreign policy, and a lot of that answer comes from Frank Church's vision of the world, which is that we have a world that's reasonably democratic, that works for the benefit of everyone, where there's worldwide competition and people live in peace. He really believed in those things and worked very hard to get there. Now, if you look at some of what might have gone on, and I'm here just speculating about things that could happen, if you get a situation like a U.S. manufacturer bribing the Prime Minister of Japan, imagine how the Japanese feel about the United States. Imagine if the head of some government that's very important to the United States is bribed by a large corporation, and some government hostile to us finds out about it and uses what the Russians call compromat, compromising the person who's taken the bribe, we have one hell of a foreign policy problem. So to me, it is an important foreign policy issue. And we will not be able to have the kind of world that Frank Church envisioned unless we look at these things in the context of foreign policy. Because more and more we come to understand that these issues are global and we all have a stake in them. If you have any doubt about that, just take a look at what's happened in the Arab Spring, where corruption reached such levels in so many countries that people rose up in rebellion, and now we have a world, well, a part of the world that's in complete chaos.
Towards the tail end of the Obama administration, Secretary of State Kerry delivered an address abroad where he directly and expressly tied corruption to terrorism. And that's something that I think sometimes gets overlooked. But if you look at some of the most corrupt regimes on the planet, they also, by and large, are regimes that support global terrorism. And the point that Secretary Kerry was making is that if we don't root out corruption and we don't enforce the rule of law and ensure that the rule of law is respected and upheld around the globe, then it is going to ultimately spawn terrorist activities that harm the United States, harm our allies, and therefore have a direct negative impact on U.S. foreign policy. And the other point I'd make is that FCPA enforcement activity has been going strong under the George W. Bush administration, the Obama administration, and now into the Trump administration. So it isn't necessarily a partisan issue. It's something where Republicans and Democrats, I think, recognize what Secretary Kerry was saying, in that corruption spawns terrorism, spawns instability, undermines the rule of law, and makes the world a less safe place.
Thank you, Jason. Well put. Professor, the last word?
Well, I'll leave the last words on the FCPA to the experts, but I would like to go back to my own roots and my early study of Confucius. And one of my favorite quotes from the Analects is that when one Mandarin above you is corrupt, then you should just quit your post and go to the mountains and write poetry. But when all of the Mandarins are corrupt, then it's time for an actual change of regime. And you see that repeated, I think, throughout history in many ways. So this is really a global issue. I think it encompasses not just business and not just profits, but definitely foreign policy. And I think, as Jack said, a vision of what the future can be like. So I'd like to thank everyone. We're going to be moving up to the boardroom in 4201 for a reception, and that will last until around 7. And then I'd like to also say speaking of global events, we have Azar Nafisi, who is speaking in the Jordan Ballroom at 7 p.m. on her excellent book, Reading Lolita in Tehran, which I read a few years ago. Has anyone read it? So you're all welcome to come to that. So you can do both events if you like. So thank you, everyone, to our distinguished guests.
Yeah, please join me in thanking everyone on the panel and Judge Sporkin in Washington.